Thank you, Gio. Good morning to you all. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Judge Grant. To my left is Judge Hodgens. We'll be your panel for all 5 cases this morning. I see some familiar faces here. So, as you know, it's 15 minutes per side. There is no rebuttal. We're familiar with the facts and the cases, so you need not go over that, but of course, how you use your 15 minutes is up to you. And with that, we will call our first case, which is 24P0154, Commonwealth versus SABBAN, SAKIB, is that how you pronounce his name? All right, and Attorney Martin.
Thank you. Good morning, Justices. May it please the Court, Scott Martin for Mr. SAKIB. I'll be brief, as I know you've considered, as you just informed us, our arguments in the supporting law surrounding same. People in Massachusetts, we all know, are allowed to operate a vehicle after consuming alcohol. However, they are not allowed to consume so much that it would diminish their ability to operate safely pursuant to the legislative guidelines. However, offering a per se .08 theory as part of the OUI statute has the intended or unintended consequence of lowering the burden of proof for the Commonwealth in OUI cases. We're not arguing that it cannot be regulated, but it's more appropriately regulated as a civil regulatory scheme similar to maybe a speeding ticket or a Mark Lane's violation, things of that nature, because the Commonwealth is relying upon federal studies that say, and they make no mistake about, no bones about this in their argument, page 20 and page 21 in the notes, that the legislative scheme and with the amendments of 2003 are to prevent likely drivers who are over .08 is people who are likely over the limit or likely impaired. That's not the standard of proof in a criminal case. That would relegate the burden of proof to the prosecutor to a preponderance of the evidence or maybe even a probable cause standard for trial.
So let's say we agree with you that scientifically an 08 should not be enough to find somebody guilty of 90-24. Are we free to overrule Commonwealth v. Heb and go against what the legislature has said?
Yes, because the legislature states the legislature is allowed to regulate it. Our issue is how they are regulating it and the unintended or intended consequences of same, how it affects the trial rights of a criminal defendant. The legislature is given wide authority. I concede that. They can come up with laws and regulations to protect the public. If we look at the breath test regulations, for example, for operators under 21, if they are over a .02, which there was always a presumption under a .05, a person is not impaired, a presumption they're not impaired, there are added penalties to a driver under 21. For a CDL operator, if they're over 04, still at the lower range, a person who is under a presumed impairment level, there are added penalties because they're a CDL driver. But that is not the standard if they are facing a criminal trial. The 08 standard came from federal tied into highway funds, which I want to address as well. I think an argument is not genuine that Massachusetts would lose highway funds if the .08 theory is removed from the impairment statute as per se. I'm not saying the Commonwealth can't, as Colteri, for example, says they can tie in the over .08 with relevant, credible evidence, such as pursuant to a Dalbert-Lanigan hearing, to tie in a correlation between the over 08 and impairment for that particular defendant. They're not prohibited from using it to show impairment. They just should be prohibited as a per se. If Massachusetts continues to make driving through the legislature illegal over a .08, I'm fine with that. But they need to do it not as part of a criminal conviction for operating under the influence of alcohol. It's legally inconsistent with the purpose of the statute, which is to take drivers, well, it's multifaceted. Not only does it punish drivers who are ruled by a jury not to be under the influence of alcohol, who have considered that breath test number in conjunction with the driving, the eyes, the speech, evidence of the consumption of alcohol, etc., have considered all of that, said this person, even though the studies say most or lots of people over an '08 would be impaired. This is not the person. Mr. SAKIB, we consider that, is not the type of person who fits in that majority category. He was not
So
under the
what do we
influence.
do with what the SJC said in Commonwealth v. Hebb? To prove a per se violation of the OUI statute, the Commonwealth need not establish that the defendant was under the influence of intoxicating liquor. Should we overrule that?
Yes, because not proving that a person is under the influence of an intoxicating liquor for an impairment statute is legally inconsistent. I don't think any plausible argument can be made that people who are operating in Massachusetts who are not under the influence of alcohol should be punished. We tell them, it's the jury instruction for the impairment portion. Alcohol affects every person differently. And then the jury is going to decide by proof beyond a reasonable doubt from the prosecution, was this person impaired? To legislate that away alleviates the prosecution of a necessary burden of establishing with real facts and real evidence at a trial. It's a clever scheme, I'll give the legislature that, but it legislates away the fact-finding function of a jury to determine the main issue of impairment.
Let me just step back for a second, because as I read the record, post-trial, the defendant raised an issue as far as inconsistent verdicts and double jeopardy. But all these other issues, and I count 4 of them in your brief, weren't raised below. So what's the standard of review for those claims?
Well, I think the standard, we did raise those issues, I believe, at trial. And we did argue that it was inconsistent.
Correct. That you argued, but all of what you've just said is being brought up for the first time. This wasn't argued before the judge. So what's the standard of review for this claim?
Well, I would say, with all due respect, Justice, and I understand your position, I think it's implicitly included in the arguments, because it's an unintended or intended consequence of the act which violates the defendant's right to a fair trial. The issue was already decided from a fact finder. I don't think anybody would disagree with that he was not, all that evidence was considered, and he was not impaired.
Well, what would the standard of review be?
I think.
I mean, is it like an abuse of discretion? Is it an error of law?
It's an error of law.
How should we be approaching this?
It's an error of law, and it's an abuse of discretion to impose that sentence, which we argued, that it's an illegal sentence, but it's also an error of law, yes.
Hold on, so you're challenging the sentence?
We're challenging the sentence as inconsistent with the purpose of the statute, which we've raised in our brief, but it's also an error of law to have the .08 statute as a per se.
So that's a separate argument.
Right, it's separate.
So with respect to the .08 as per se,
Yes.
what's our standard of review if you didn't raise that explicitly below? That's the question.
I believe we did argue that below. That
Standard of review.
Well, the standard review, I believe we argued. I think it's right, because we argued that he could not be found guilty of a .08 after the jury acquitted him of being impaired.
That's inconsistent verdicts. What's the standard of review? I haven't heard the direct response to what the standard of review is yet. So can you just tell me that?
I believe it's a ripe issue where it's an error of law that you can consider that.
Error of law.
Yes.
And you don't think your argument is best suited for the legislature?
It's not, I anticipated that question. It's a great question. It's not best suited for the legislature because it affects a defendant's right to a fair trial. It's more appropriately ruled upon by the justices, by the judicial system. The legislature sought to circumvent a jury decision by enacting the 2003 amendments to the OUI statute. It's clear, because what it says in Kulturi is that it would be more prejudicial than probative to put in that type of evidence, a presumption. It says they take away the presumption given to a jury. What they really did is took away all of the decision-making authority to a jury for the second theory. And our argument is that it's not really even a second theory. It's a second bite at the apple for the Commonwealth to circumvent the verdict on the impairment theory. If we were to have...
Well, that's not really fair to say, though, that the jury had its decision-making power taken away. The jury was not bound to accept evidence of the breathalyzer or what the reading was.
But they did accept it.
Okay, but they had a choice. So their decision-making power was not taken away. In fact, the instructions made clear that it was their decision as to how to weigh the evidence, right?
Right. And then, so they rendered a decision that Mr. SAKIB was not impaired, considering the breath test and all of the other credible evidence. So then we move what the Commonwealth describes as a second theory, is that, well, if he's over an 08, we consider it a presumption that he is impaired. It's not a lesser included offense. If he picks up if he gets charged for a subsequent OUI and there's no breath test, it's only impairment. Despite being found not guilty on the first trial for impairment, on the impairment theory, he still faces a second offense. How is that fair to a defendant? It's punishing a person who is acquitted. So the second theory, they tell the jury, we used to require the prosecution to bring in an expert or have a hearing or produce credible evidence as to why over .08 ties in and correlates with impairment. Now you don't consider that at all. Only if it's over .08. And that over .08 is based on research that people may likely be or probably are impaired over an 08.
But
the
again,
jury
this goes back to what Judge Grant was saying, that in the HEB case, the SJC seems to have addressed your argument and rejected it to make clear that for the .08 charge, it's not saying that someone's impaired. It's just saying that to prove an impaired ability violation of the statute, the Commonwealth need not show that the defendant's blood alcohol level was .08% or more. So in other words, it's that your blood had a certain percentage of alcohol. That's what the charge is. It's not saying that you were impaired. It's just that that's what your alcohol reading was in your blood.
And I understand, but it begs the question, how is that legally consistent with the purpose of a statute, which is to stop impaired drivers? How is it legally consistent with a trial right of proof beyond a reasonable doubt?
The court addressed that. Thus, the charging decision was consistent with the legislative purpose to minimize the risk to public safety from drivers who are either actually impaired or presumed to be impaired based on their blood alcohol level.
Right.
So it's to minimize the risk to public safety.
Right. And to minimize the risk of public safety, when we say they may be impaired, that's not the legal standard for a conviction. And I don't believe it was argued this way. And this is why I state, this is a first impression, it was not properly argued that it lowers the burden of proof on the prosecution. We don't argue that the legislature cannot set a .08 limit. It could be part of a civil regulatory scheme. It cannot be used to lower the burden of proof in a criminal case for proof beyond a reasonable doubt, or to nullify the verdict on an impairment. This is an impairment statute. The same way if we had a murder, you couldn't say if there's no death, as the example we give in our brief. If you have a murder and there's no death, but there's a study that says most people who are shot die, and then you say, well, the Commonwealth is going to institute a second theory through the legislature that was the person shot, yes, and they suffer a murder conviction, but there was no death.
The part that Judge Hodgens just read was presumed to be impaired. And so I assume that when the legislature passed this statute, that they must have heard expert testimony saying things like somebody who's a chronic alcoholic can have a blood alcohol level over 08 but still seem to be functioning, but they could still be a dangerous driver. I'm assuming that, I'm inferring that.
I anticipated that.
But we as a court don't have a forum for hearing that kind of information from doctors and scientists about, and substance abuse experts. So how can we, as a intermediate appellate court, go against what the legislature said and as interpreted by the SJC and HEB?
Because it's inconsistent with the ruling in Kulturi. I anticipated that would be the example, that it's a chronic alcoholic and we want to keep this person off the street. That's not the case. It could also be a person who's larger, and the decisions talk about people who ate food or their difference in gender, health, tolerance, and what have you. But Kaltori says there is a mechanism for the Commonwealth to prove that. They bring in expert testimony and show that there's a correlation between over 08 and impairment. What the legislature did is alleviated the Commonwealth of that burden by just taking that issue off the table. But the jury already considered it. Where the jury already considered it, why is the jury allowed to consider it for the impairment prong at all then, if it's not a relevant factor to determine impairment? If it's per se impairment, why is the jury considering it at all for prong number 1? They consider the breath test. It's in the instructions. You can't consider it alone, but you consider it in conjunction with all the other credible evidence which is appropriate for a criminal trial. They did that. The jury rendered a verdict, a fact finder, which you're entitled to as a criminal defendant, and said no. So now to circumvent that decision, that jury verdict, which is the most sacred in our criminal jurisprudence, the legislature got crafty and said, we'll circumvent that by just taking impairment off the table, saying it's per se, no due process rights to challenge that. Where's the due process to say it's per se, and the jury only decides if over 08 was accurate? But the jury already said you're not impaired by it.
So I see that's your time. First question is, what's your best case? Do you think, first of all, do you think this is a case of first impression, or do you think this argument's been made repeatedly before?
I think the arguments we are making are predominantly first impression, but some of the arguments may already have been incorporated, but it's predominantly a first impression because it's attacking that because the Commonwealth is relying upon maybes and mights and what have you, it's lowering the burden of proof.
I understand.
Right.
What's your best case?
Well, when I look at Kaltori, for example, I think it's a best case because it does spell out how the Commonwealth has to prove the correlation between over 08 impairment and a specific defendant. The Commonwealth, Commonwealth v. Campbell, for example, talks about negligent operation. Speeding alone cannot be negligent operation. Combined with other driving and other factors, they could reach that.
Do you think Kaltori is your best case?
Kaltori is supportive of that one proposition. Commonwealth v. Campbell, as I argued, where speeding alone is not enough. You could not then go to a second theory and say, well, was the defendant over 65 miles an hour? I'm sorry. I didn't mean to interrupt you.
Thank you.
Thank you. Okay.
Good morning, may I please
Attorney
support?
Johnson.
Catherine Jansen for the Commonwealth. This amounts to a disagreement with a policy determination by the legislature. Driving is not a fundamental right, so there need only be a rational basis with the way that they have criminalized impaired driving or presumptive impaired driving. And I think Justice Grant hit the nail on the head that the legislature is best suited to make this determination that .08 is a blood alcohol concentration level that many people are likely or might be impaired because, as we know, when they are deciding to enact laws, there's often testimony and hearings on this, and they were in the best position to make this policy determination. I would also suggest HEB is directly or the most analogous to this case, and I don't think this court can overrule an SJC case, that this does not change or reduce the burden of proof for the Commonwealth going forward on two alternate theories. The jury has to decide whether or not the Commonwealth proves beyond a reasonable doubt whether the defendant had a blood alcohol concentration of .08 or higher, and they make a determination based on the credible evidence of that.
Why .08?
Well, I believe from when the legislature added this amendment in 2003, they did hear testimony from experts and other people about what blood alcohol concentration levels do and how they affect people. It's not really part of the record, right, in this case, but that was a legislative determination to determine what blood alcohol level. If they wanted to, they could have raised it or they could have reduced it.
But I'm just asking why .08? It has to be rational, right?
It is. Well, and I think part of it is it's rational because I'm saying they likely, or I think they did, and I don't have that as part of the record, but testimony regarding the effect of that on the majority of people, and it's rational because as long as it might, or their goal is to reduce dangerous people on the street who might or likely could be impaired, and they made that determination that .08 is that litmus level.
So Coteri says, to strengthen the protections afforded the public from drivers who might be impaired by the consumption of alcohol. Think that's a rational purpose to do that?
I would say that's a rational purpose. That's that was the legislature's purview, and I think that's a rational basis that they want to keep people off the street who might be impaired. Not that they are, but they might be.
What about the argument, which counsel wasn't able to get to, but I think he alluded to it, the 24D program, if it's designed for, essentially for people who have a drinking problem, right? If he's not convicted of being impaired, is that an appropriate program for someone to be involved?
I do, and I think I addressed it in my footnote based on these facts, especially, I think, specifically based on these facts, but I think even if it's somebody has a .08 or higher, because you're making a decision we don't know based on, and I'm sure the legislature probably heard testimony to this, as Justice Grant had alluded to, that you could be a high-functioning alcoholic or have other things going on, and you're still choosing you still could be dangerous just because you may not, quote-unquote, exhibit the traditional signs of impairment that somebody else might have. For example, somebody might not have a .08 and exhibit signs. And so, especially here where he had double the legal limit, the whole point of the education program, I think, is still met when you are convicted of having a .08 or higher, because you're still drinking and could still possibly have or be impaired, if that answers your question.
So there is a connection, even if it's
Yes.
not as a strong connection, if you had been convicted of being impaired.
Yes, I think so, because you're still drinking and driving, and you're still drinking and had consumed enough drinks that could affect your ability, and it suggests that you're not making good decisions. And so I think the alcohol education program would be helpful for that. And so I think there's a rational basis to that punishment.
And what does the Commonwealth say about the standard of review here? Because as I had mentioned before, as I read the record, there was a brief discussion after trial about the inconsistent verdicts, and then, oh by the way, there's a double jeopardy claim too thrown in there. But all this other arguments about the 24D program, the per se statute being unconstitutional, the jury instructions, none of that was raised. So what's
Correct.
the standard of review on this?
When you were asked that question, I thought about that, and to be fully have candor with the court, I'm not entirely sure the answer to that, because these are a variety of issues. I think when you're looking at a statute, I'm not sure the issue is whether it's preserved or not, although I think you were looking at, like I said, standard of review for a statute would be whether it's rational basis or strict scrutiny maybe, but for some of the other issues, it's not preserved, so you're looking regardless of whether there's a substantial risk, I guess, but I don't have a good answer for you on that because I'm not totally sure of the answer, so I apologize to the court, and I can...
There was a civil infraction of speeding, is that right? He was alleged to have been going 68 miles per hour.
I believe so, and I believe that was
Not responsible?
Guilty finding. Or
You're not responsible.
Not responsible, is that right?
Finding, yeah. I'm happy to answer any questions the court may have.
Hearing none, the matter stands submitted.
Thank you.
The next matter on our list is impounded, so no names. Docket 23P1458, Commonwealth versus Juvenile.
Good morning, may it please the court. Attorney Michelle Mencken on behalf of the juvenile. Today I plan to address the Miranda issues, specifically the questions of custody and waiver and attenuation, and if time permits, the interested adult issue. If the court has questions about the judge's refusal to qualify the experts, I'm happy to entertain them, of course. But otherwise, I'll focus on trying to persuade this court that the questioning of this juvenile did not pass constitutional muster.
In both interviews, or in the second interview, or where?
Both. I view this as one continuing questioning with two legs, with a strange interruption in the middle that is unexplained. I think that the first interview is unconstitutional because the juvenile was subjected to custodial interrogation without an interested adult and without the benefit of Miranda warnings.
So with respect to that, what are the police to do? We have a shooting that takes place. The juvenile's friend is shot in the head and killed. It's nighttime. The juvenile calls the police. The police are looking for some people out there with guns who are shooting folks. Is it your position that they shouldn't be asking the juvenile, what did he look like? What shirt did he have on? They shouldn't be asking any questions that are going to help them identify who that shooter was as quickly as possible.
No, of course, that's not my position. But my position is where the police had knowledge that there was a firearm in the car that the juvenile admitted being in, the record shows that that raised suspicion of the juvenile's involvement in criminal activity.
I'm not sure when you say the record shows that that raised suspicion of the juvenile. In the first, let's talk about the first interview.
Well, so at the time of the first interview, Detective Callahan knew that
there was a gun.
That there had been a gun.
Yep.
And Detective Kornetsky testified at the suppression hearing that that knowledge would have precipitated Miranda warnings. He testified that he believed that what changed at the second leg of the interview was that Callahan had just learned about the gun. He said that at that time...
Hold on, I get all that. My question to you is, what should the officers have done? You think that the officers should have given the 17-year-old juvenile Miranda without an interested adult?
I believe he should have had an interested adult and Miranda
Okay, so that's my
warnings.
question. So you're saying that they shouldn't have asked him anything in an effort to get these shooters off the streets right away. They should have waited until an interested adult came, maybe an hour later, and then asked them questions. But they shouldn't do anything in the moment. Is that what I understand you to say?
Well, with respect to the juvenile, so the juvenile has a constitutional right not to furnish the police. Well, I'm trying. I am. So they have other investigative avenues. There was an impressive police response to the scene.
I get it.
I'm not suggesting that they...
So they shouldn't have any conversation with the only eyewitness.
Correct, because they know that that witness is potentially involved in criminal activity.
They don't know that. They know that he called 911, right?
Well, the record shows that that's why I was referring to Detective Kornetsky's testimony as to the second leg of the interview, because Detective Kornetsky said that the knowledge that there was a gun in the car where the juvenile was raised questions about whether the juvenile was involved in criminal activity.
At that moment, when the police arrive, they don't know where anybody's sitting in the car, because nobody's in the car, right?
Well, the driver was in the car at the time.
Driver was in the car.
That's correct. He was
Slumped over in the car, still in the car.
in the driver's seat.
And the gun was found on the passenger side.
It was found on the driver's side after the driver was removed.
All right. So how does that implicate the juvenile?
Well, as Detective Callahan said during the questioning, it raises question about friendly fire. It raises question about whether the juvenile was firing back at any of the people that were assaulting the car. It potentially connects the juvenile
You're
to
talking about the second interview now.
I'm taking the evidence from the second interview to answer Justice Desmond's question about the first interview.
Right,
So we
but I don't
have
want to talk
evidence
about,
about
but I
what
want to
this
confine
meant
our
to the
discussion.
police.
Let's look at it. I know you want to look at it as one continuous interview. I'd like to, for purposes of this discussion, take a snapshot of the first part, and let's figure out the propriety of the initial interaction with the juvenile in the immediate aftermath of a kid who got shot in the head. So what should the officers have done? Is your position that they shouldn't have done anything? They shouldn't have asked him any questions. They should have waited until he had an interested adult, and then...
Yes, absolutely, and I don't think that that's an unreasonable position. This was a 17-year-old child who had just been in a car that was assaulted by a hail of bullets, and his friend in the driver's seat was shot in the head, and the juvenile had tried to commandeer the car and crashed. This is an incredibly traumatic event, and I think it's perfectly appropriate and should be encouraged for the police to take a beat, get an adult. I mean, the question that Callahan...
And not immediately look for the killers.
I think they should immediately look for the
But
killers.
they don't know what they look like. How are they going to get any helpful information?
From the street, and there was a
What
caller.
do you mean from the street?
Well, there was plenty of ballistics on the street. There was a caller. We have the CAD, the computer-aided dispatch sheet in evidence, and one of the callers said that they saw 3 people chasing the car. There are other investigative avenues besides the juvenile himself. The juvenile cannot be pressured or manipulated into furnishing evidence
Did he appear pressured
that
to
can
you
be
in the
used.
first interview?
No, I don't think that except for the coercive environment itself. I mean, he was pressured because he was taken in custody. He wasn't given...
I'm just asking, I understand your position, I do. I'm just asking you, did he appear pressured? When you look at the first interview, let me ask you this question, I'll frame it a different way. When you look at the first interview, do you think that that was investigatory?
Well, I know that the police knew that there was a gun in the car, and I know...
You didn't ask him anything about the gun in the car.
Yes, but we don't know why, and we do know...
So my question calls for yes or no.
So I think that maybe what you are asking me to say is that the police adopted a humanitarian tone with the juvenile during the first line of
No
questioning.
question. You said pressured. I'm asking you, did he appear pressured, first of all?
I think that that legally cognizable pressure is observable in the place of the interrogation, the presence of seasoned homicide detectives.
I'm asking you.
Well, that's my answer. That's my answer. That's how he appeared pressured to me. He had just come off of this traumatic experience. He's given no other option. He is brought in custody. He has no experience being questioned by police. He's never been charged,
How do we
arrested.
know that? How do we know he has no experience with questioning by the police?
Well,
I didn't see that in the record, and how do we know that?
Well, we have it through the interview and the report of Matthew LaHaye, who did evaluate Jared. But we did have also Detective Kornetsky's testimony. I believe it was Kornetsky. One of the police officers testified that this juvenile had no record.
Having no record does not mean that he didn't have any other interactions with the police.
Fair enough. Fair enough. But there's no evidence that he did, and this is the Commonwealth's burden.
So I have a question for you. Your brief quotes Rhode Island v. Innis as saying that custodial interrogation is questioning that the police should know is reasonably likely to elicit an incriminating response. If the police know about the gun, and for that matter, they know about the marijuana that the defendant has, and he's 17, so he shouldn't have it, but they don't ask about that, either of those, which questions in that first interview are reasonably likely to an incriminating response?
So first, to clarify, an interrogation is either questions reasonably likely to elicit an incriminating response. That's sort of the functional equivalent analysis, or express questioning by police. I don't think there's really any debate.
Could you say the second part of open?
Sure.
You said
or
functional equivalent or?
express questioning by the police.
Okay, thank you.
There really shouldn't be any question, any doubt that this was an interrogation. This was an interview by police. The only question is whether it's custody. And I think that the Commonwealth's brief doesn't seriously argue that it's not an interrogation. I think that they talk about the tone of that first interview, which can be relevant to the custody analysis, but of course, adopting a humanitarian or investigative tone like that is also recognized as a form of leverage. That's not the end of the analysis. So, but also, Justice Grant, there were questions that that could reveal, so he was asked about whether he was there to purchase marijuana. He was asked if he was in a gang. He was being asked basically, what were you involved in that precipitated this? So those can possibly inculpate the juvenile. And they also formed a chain and a link. So the police, I don't think that we can just divorce the fact that Callahan knew that there was a gun in the car. So the reason that I kept referring to what Callahan said in the second interview is that that's evidence that bears on the nature of the first interview. It is recognized that police can employ a tactic of beginning an interrogation in a very sort of friendly, open, you have nothing to worry about manner. And then once getting enough information that they can couple with the information they know to really go deep and pointedly with the witness, to then administer Miranda warnings. And this court and the Supreme Court of the United States have said that that is not a permissible tactic, and that is the very reason that the presumption of taint was created, was to address that situation, to curb police conduct from doing that, from sort of manipulating a person into thinking
let me just,
that they
if I
can
could just
speak
go back
freely.
though, because to what Judge Desmond was asking you about, because whatever rule of law you're advocating for, it has to be reasonable. So, as I understand your position, when he's at the police station, the juvenile's at the police station, your position is there shouldn't have been any questioning during that first interview until mom showed up.
Correct.
But what about when he was out on the street? Are you saying that the rule should also be the same for out on the street when the police first arrive and they're speaking to him and they're trying to figure out who he is, what's happened here? Are there suspects still at large? Is someone hiding in the bushes ready to fire at the police? Are you saying that they should be waiting for mom to show up there?
No, Your Honor, I haven't taken that position, and I think.
All right, well,
that
what
there-
about that questioning then?
So there are circumstances, and there's plenty of cases where people are questioned in a situation out on the street, and they may have enough indicia that there was custody to make an argument that that initial questioning on the street should be suppressed. I didn't make that argument here. But I think that once that initial questioning happened, and the police now know that this was the only passenger in the car, and they know his sort of connection, they now have a serious issue, which they basically admitted. Detective Kornetsky basically admitted knowing what we actually knew, although Kornetsky didn't know it, but knowing what Callahan knew at the time that the juvenile was brought in involuntarily by armed uniformed police officers in a marked cruiser, that an adult should have been called and Miranda should have been administered at
So
that time.
let's say that that your client was a 17-year-old girl who reported a rape and was taken to the police station and was questioned about what happened. And as she's being questioned, the police are thinking, this doesn't add up. We're going to pull the video. This doesn't make sense. And at some point, she starts making statements that the police know might be incriminating her for false report of a crime. Are you saying that police shouldn't have questioned the rape victim without a parent present?
No, I'm not. I mean, that's a different situation than we have here. There, the police obtained different information that changed the character of the questioning. And a comparable case that's cited in our briefs is Osacek, I hope I'm pronouncing that right, where this was an overdose death, and someone who had been using drugs with the decedent came in and sort of, they thought that he was just a witness, and they're talking about how the night went, and as things are progressing and they're gaining more information from another witness, the police are starting to recognize that this is potentially a suspect in criminal activity, and the court, the SJC, talks about where Miranda needed to be given there. Here, nothing changed in terms of the police knowledge. Nothing changed from the first interview to the second. They had the knowledge at the first interview, and the Commonwealth has has failed to explain, has failed to show that that wasn't exactly the type of overbearing coercive method that has been prescribed in cases like Smith.
So, I don't want to interrupt your answer to Judge Grant. I'm going to give you a few more minutes because I've got
Thank
a
you.
couple more questions. So, had you finished your answer?
Yes. Thank you.
Do you think that, so it's your position that as soon as they told him, listen, what we're going to do is we're going to bring you down to the station, we're going to ask you some questions, right then he's in custody?
Yeah, well, yes. And when they frisk him and they say, we're going to ask you some questions because this doesn't look like just a car accident.
Now-
There were weapons involved, and I need to frisk you because there were weapons involved.
course.
At this point, and then he's taken in custody, so.
That part, I mean, the frisk, I think is reasonable, well, reasonable minds may differ, but.
We haven't challenged the frisk, and I just
Do you
want to.
think in the first interview, they elicited any incriminating information?
Well, they did. They elicited pieces,
Tell me what they elicited in the
his
first.
presence in the car, the exclusion of anybody else being in the car.
We know that when he called 911,
Yes,
the nature of the incident.
yes, but I don't know that that changes the analysis, that they already knew the information. Here they have it, and they have, the question about whether they elicited incriminating information bears on the attenuation analysis. So,
Well, hold on. I know
Okay.
the second interview, we haven't gotten to yet. But in the first interview, what incriminating information did they elicit?
well, are you asking me what did they elicit that they didn't already know? I mean, they got a lot more detail, sort of about the travel of the car. They got phone numbers that could be used to check locations. They got a lot more detail. They knew the general parameters, but in terms of connecting this child to the gun, they got enough to connect him to the gun. I mean, being present in the gun, in the car with the gun.
To the first gun?
Yes, is constructive possession of that gun. So
Was the second gun ever recovered?
it was, and it would have been recovered inevitably, so, which bears on your question about what were the police to have done. They could have done everything that they did to this date without ever having spoken to the juvenile.
I have a quick fact question. At the beginning of the first interview, the police asked something about the juvenile's parents, and I couldn't hear the juvenile's response. Do you know what he said?
He said no. I called my brother, but he said, does your parents know where, I'm sorry, he being Callahan asked, your parents know where you are, have you talked to them? And he said no. The response from the juvenile was no, and I think later he indicated that at some point he had called his brother. And the record indicates that the juvenile's parents were not really his adults.
But that reference to the parents is not enough of an opportunity to consult with a reasonable adult.
No,
I mean,
because, what Callahan should have done at that point is say, why don't you tell your folks where you are? I mean, this was an emergency. And, when the mother testified and said, I got a message from the police.
Why is it an emergency?
Well, he's just had his car shot up and his best friend murdered in front of him.
Exactly.
So for Detective Callahan to call the mother and say, don't worry about it, it's not an emergency, struck the mother as really inappropriate. And I would hope that it would strike this court that way too. In terms of from the initial,
So a few minutes go past after the initial interview, right? He's in the car, and they're taking him, where are they taking him?
to his mother's house.
To his mother's house.
Yes, which is his address in Boston, is what he told police.
And then, I don't know, how long would you say he had left the station before they turn around and come back? 10 minutes?
Yeah, it was somewhere between 8 and 11 minutes, is my memory.
And so, so the judge found that there was an attenuation between that first interview and that second interview. And she found that in the second interview, he was properly Mirandized, and therefore any taint from the first one didn't carry over to the second one. Right?
Correct, that was her finding.
Okay. And you say?
And I say there was no cognizable break. There's no.
He's still in custody. He's in custody at the station. He's in custody in the car. He's in custody when the car turns around, and he's back in the room again.
Correct, and he hasn't spoken with anyone. He hasn't. So the only case that's cited by my sister is the Watkins case, and in that case, during the break, the suspect had called and spoken with his mother and sister and then decided to speak after consulting with them. Here, there was no change. I mean, the juvenile was silent, and I think it's an important fact from the record. The juvenile was silent the entire time unless spoken to. He volunteered nothing. He didn't control the contours of this questioning in any way. In the car ride from the scene to the police station for 15 minutes, he was silent. In the elevators, he's silent. You see this in the body cam. Going in, he's silent. He speaks when he's spoken to, very cordially. There's no report of any discussion during the transport. He comes back in, and he is silent. Callahan says, "I don't want you to say a word," and he doesn't say a word. So there's nothing that shifted this, that dissipated the taint. In fact, when the juvenile does start speaking, he says, I already told you. I was in the car. I told you this is what's going on. And you see exactly, this is kind of the classic case of subtle pressure that results in an incriminating statement without any thought being given to it. He volunteered. We both had guns. They never would have had that. I mean, they had the gun that was found, but they now have his...
Did he volunteer that, or was he asked that question? I mean, I think the officers, as in response to that, this is why we ask questions.
Yes, that's right. And he is being asked about the gun, which gun was Isaiah's gun, and he says, well, we both had guns. And they say, when he said, Boston is a dangerous city.
They asked a lot of times in the second interview, did you fire a gun? Did the driver fire a gun? Did they ever ask those questions in the first interview?
They didn't ask about guns at all during the first interview. I mean, they asked about the juvenile's activities that brought him there, what he was involved in, and so forth, and then descriptions of the people that he said had fired upon the car.
After the first interview, or toward the end of the first interview, they photograph him.
Correct.
What do you say about that, if anything?
Well, the way that the second interview ended is indicative of the
second or the first?
This is a continuing.
So at the end of the first interview, don't they tell him, hey, just for a second, I want you to stand against the wall because we're going to go back, we're going to pull some video, and we want to make sure that we kind of capture what you're looking like? Isn't that at the end of the first interview?
Yes, you are correct. You are correct. Thank you for jogging my memory on that. And so the way that the first interview ended, of course, is relevant to the custody analysis. And the first leg of the interview, I want to correct myself, that he left in custody and that he did have those pictures taken. It just shows the coercive environment. And that the impression that a reasonable juvenile would objectively have that he was not at liberty, that he was in the police custody and control.
With respect to going over the Miranda in the second interview, so now he's there, his mom's there, they've got the form in front of them. Do you take any issue with how that was?
Well, so my issue is that there was no point of waiver, so separate and apart from the question of attenuation. I think that the second leg of the interview fails of its own right because when was the waiver? So a lot of Miranda forms, as I'm sure this court is aware, and we've cited plenty of case law. In fact, the only cases that my sister cites on waiver are cases in which there was a form that said at the bottom line, having these rights in mind, do you wish to waive
That
them
required?
and speak with us? I'm not suggesting it's required, but it wasn't present here.
But he
So-
asked him that, though, right?
No, he was never asked. The police never asked whether the juvenile would wish to waive his rights.
Well, not whether we wish to waive them, but doesn't he ask at the end of going through the form, so, I'm paraphrasing, you want to talk to us, or so, we got some questions for you. Do you want me to leave so you can talk to your mom alone for a minute?
There's not a question, do you want me to leave? The officer says, you can have an opportunity to consult, but just keeps talking. And there is no question about, do you want to speak? I'm not sure what the waiver is.
Are you saying that the error is no affirmative waiver, or are you saying the error is,
Not asking if it's an affirmative waiver.
you're not saying he invoked?
Well, I'm saying there was no affirmative waiver. And this is actually a really interesting issue. It's raised by the Clark case, and this court has, in an unpublished decision, previously declined to weigh in on this. But the law...
In Clark, they're shaking their head no, and they keep asking him questions, right?
I'm sorry.
In Clark, the
Oh, that's
defendant
true.
is
There
shaking
was
his head
a...
no,
That's
and they
right.
keep asking questions. So
That's
they
right.
said, listen, you got to scrupulously honor the invocation.
So, right. Well, I believe that Clark had both sort of analyses, which is the original waiver and then invocation after a waiver. I think the main issue in Clark was invocation after a waiver, but I agree with you that there was sort of a nod or a gesture that could be understood very clearly as a yes or a no, whereas in this case what we have is silence and the juvenile is just putting his head down
Isn't he
in his
nodding?
arms.
Don't we have the detective saying, oh, I see you nodding yes, and then going on to the next question?
That he understood the rights. So I'm not disputing that the juvenile and his mother indicated that they understood the rights, but there's no indication. The only possible indication of a waiver here is the fact that after 2.5 minutes of straight questioning while the juvenile had his head down on the table, the juvenile finally spoke. So the question for this court is that an implicit waiver that Massachusetts will sanction under Article 12? Because they have generally disfavored any implicit waivers of constitutional rights. And the Clark case has a lot of language about how sort of illogical it is to require that the right to silence be invoked. It puts the burden on the person who has the right by doing something other than remaining silent. And so they say the police need to be really clear in obtaining a waiver. And I would urge this court that particularly in the case of a juvenile who has just been through a traumatic incident and who has little to no experience in the system at all, that there should be a clear, having these rights in mind, do you want to go ahead and talk to us? And the police can use their encouraging, this is why we want you to talk to us, but they need to get, with certainty, the juvenile's decision on this
At no point did the
waiver.
interested adult say, hey, hang on, he hasn't said he wanted to answer your questions.
No, the interested adult did not, and that raises I think the interesting question about the interested adult, and is there sort of an independent analysis of the adult's capacities?
Well, certainly she had the capacity to tell him, listen, the answers are, I don't know. Stop with the gun, stop with all this other stuff. The answer is, I don't know. But I think we're going to have to leave it there for now.
Thank you.
Thank
I
you.
see my time is up.
Attorney Martinelli.
Good morning, Your Honors. May it please the Court, Jacqueline Martinelli for the Commonwealth. I'm asking this court to affirm the motion judge's order denying the defendant's motion to suppress. First, starting with the first interview.
Do you agree that he was in custody the whole time?
No, Your Honor.
Okay, when was he not in custody?
He was not in custody during the first interview.
Did he have an opportunity to say, no, I don't want to go to the police station?
Well, when the officer, when Lieutenant Brooks stated to him, we're going to have you go to the office, we're going to give you a ride, all right? He responds, that's fine. So it's my understanding that as a 911 caller, as a victim of a crime, as he was just shot at and in a car accident, he called for help.
Is that the same as saying, do you want to come? When we're telling you, we're going to take you down to the station, we're going to have some questions for you. At that moment, the juvenile is supposed to say, no, that's not all right?
Well, also Officer, or Lieutenant Brooks also testified that he never said that he could not leave or anything, but understanding
I
your
understand,
point.
but I'm asking you, when they're on the sidewalk, and he's telling this juvenile, this is what we're going to do, this is the game plan, this is what we're going to do. Are you saying that the juvenile should have had the wherewithal to tell the officer, no, I don't want to do that?
I think it's harder for a juvenile, yes, Your Honor. I agree that it's definitely harder as a juvenile, but in this case, when he says that's fine, the indication is that he is willing, especially in the totality where he was a 911 caller seeking help for his friend.
At that moment, did they know he was a juvenile? At that moment, did they already have his date of birth?
I don't believe so, Your Honor. They might have. I'm not exactly sure. I know Lieutenant Brooks is asking questions, but I'm not sure if at that point that they knew he was a
Let's
juvenile.
assume for the sake of discussion that they did have his date of birth at that moment. So now they know he's a juvenile, right?
Correct, Your Honor.
So should they even be asking him, is it okay?
Well, at this, again, I think this is going back to your additional point. Your point to counsel is that this was an emergency. They're trying to figure out what's going on. This juvenile called 911, asked for help, is telling the police what happened. And then they do have further questions as this is such a serious case. This is potentially murder at this time. And they are looking to ask questions and try to find the suspects who are still at large at this time. He was never handcuffed. He was only placed in a back of a cruiser without lights and sirens. It was a very short ride. It was a 15-minute ride from the station.
The question is, did he have a chance to say, no, I don't want to do any of that?
He had a chance. I do believe he said, when someone's asking you, we're going to give you a ride, all right, and they say that's fine. I think when someone's asking you all right, even as a juvenile, you would have the understanding that you could say, no, not okay. And when someone's asking you all right, I understand it's asked as it was asked, but still, I think that the juvenile still would have had an opportunity to say that, especially when he said that's fine. Turning to when he's in the station, so he was not subject to custody at that time. Looking at all the different factors, again, looking at the context of that he was a victim, he called for help, he was trying to help his friend. There's no evidence that he protested going to the station. It was a 15-minute ride, not handcuffed. In terms of the interview, it was non-accusatory, it was cordial. Looking at the groom factors, all of the factors in its totality shows that he was not in custody, despite being at a police station that's not dispositive of custody. And then looking at the second prong in terms of if there was an interrogation, the motion judge correctly found there was not an interrogation here, as the questions that were being asked by officers here were not reasonably likely to elicit an incriminating response by the juvenile.
What's the difference between express questioning and interrogation?
Well, so I'm reading, as you asked counsel, as counsel made that point, I'm looking at Rhode Island v. Innis, and it says the term interrogation under Miranda refers only to express questioning, but also to any words or actions of part of the police officer that the police should have known would reasonably likely elicit an incriminating response. So I think that while there are questionings, while he was being questioned, it still had to elicit an incriminating response. And that is, again, when we have threshold inquiries, when we're on the scene asking questions, this is what happened, where were you going, who were you with, did you see the race of the shooters, did you see the age of the shooters, did you see who had a gun? These are all very specific questions that right now there are 3 individuals that just shot into a motor vehicle that potentially killed someone that then did kill someone. So the gravity of this is important.
But they're also asking him, have you been to this area before? Why are you going to this area? What apartment did you go to? What's the name of the person whose apartment you went to? Isn't that all possibly incriminating information?
I wouldn't think that those questions would be incriminating, given that they're just trying to figure out why they were going to, especially I think even more evident when they're asking if the victim, in this case the deceased victim, had the car, if anyone else used the car, if they're trying to maybe see a potential motive, if they were just driving the car in the wrong place at the wrong time.
Potential motive, couldn't that possibly be incriminating?
Well, potentially, and I think, but it's important here to look at the reasonableness and in the context of these questions when they're asking the juvenile, was the victim trying to meet a girl? Was there any indication that someone could have set him up? They're trying to find the motive of the shooters to solve the shooting. It's not an investigation on the juvenile. They're not asking.
Right, but the motive could have been, we're gangbangers. I mean, they're asking them, we're J-Way or whatever. I mean, isn't that possible?
Well, I don't think being in a gang itself constitutes a crime, but
It doesn't.
So, I mean, but they're just trying to get background and context of what's going on so they could try to better find the suspects that are at large at the time. After that, and again, as your honors are aware, that there was no firearm.
Well,
issues with the
isn't
firearm.
the critical question not so much what's on the minds of the police, but what they are communicating to the person being questioned? So in other words, the police could be investigating all manner of crimes that may have taken place, but as I saw that interview, at no point, that first interview, at no point did they communicate to the juvenile that he was a suspect.
That's correct. Your
So
Honor.
they may very well have been trying to figure out, okay, what apartment, what were they going to, what's really going on here, but they didn't say anything to the juvenile, right?
Correct, Your Honor. And that,
So are they trying to figure out, is he a suspect?
at that time, they did not, it does not seem anything from the testimony, from the record, that they were
What is it
looking.
they're trying to learn?
They're trying to learn who is involved in the shooting, who is the suspect at that time. It's an emergency situation.
And that could include him, right?
And I think it's very specific that why they don't ask about the gun. They don't ask any involvement about the gun, of his involvement. He's just asking questions. Where are they going? Were they going to meet anyone? It's very specific to the crime itself, the shooting, not to any culpability of the juvenile at that time.
Is it the first interview that they talk about the friendly fire?
No, that's the second interview, Your Honor. I'm turning to the second interview. If there are no other questions about the first, at that time,
So just to be clear, your position is during the course of the first interview, he was at no point in custody.
correct, Your Honor. In terms of the second interview, the juvenile knowingly, intelligently, and voluntarily waived his Miranda rights with his mother present, and his rights were honored at every step of this process. Not only did he, before Detective Callahan asked any questions, he was very upfront with both juvenile and his mother, instructed the juvenile not to say a word, that there was a gun in the car, and the gun is against the law, and we want to ask questions about the gun. And then did Miranda, line by line, used a form, had the form in front, asked to initial after every line, asked the juvenile if he understood after the first couple of questions to make sure, which none of this is needed, but he still took his time. And you can see clearly, as Your Honors saw on the video, the juvenile signing, passing the pen to the mom signing.
If one were to conclude that the first interview was indeed custodial, does that infect the second interview, notwithstanding the line-by-line Miranda that you're talking about?
No, Your Honor, and I think that goes to the taint argument. If Your Honors were to find that there was a custodial interrogation in the first interview, there was clearly a break in the stream of events here to dissipate any taint.
What was the break?
So the break here is first, the first interview was over. It was an hour and 15 minutes until the second interview. During that time, at the end of interview one, the officer asked him to go, if he wants to get cleaned up, if he needs to be seen by EMS, if he needs to make any calls.
Was he in police presence the entire time?
He was, Your Honor. He then was driven to his home, his mother's home in Boston, and that's when the decision was made. I believe it was about 7 minutes from when they left headquarters to when they turned around and came back to headquarters, because they wanted to do a second interview about the firearm specifically.
Had they reached his mother's home by the time when they turned around?
I am not sure. I don't believe that's in evidence. I know the mother testified that she was asleep, got a phone call. I know that from the record that it was an hour and 15 minutes in that whole time frame before the mother was in the room with the juvenile. I know that Detective Callahan said on the interview that he had a conversation with the mother prior to them being recorded, but I'm not sure exactly when the mother arrived. I don't believe that's in the record. In terms of the Tate, Your Honor, again, this was a completely separate interview. Not only having his mother present, being told that this interview is going to be explicitly about the firearm, and having his Miranda rights given, this was a completely separate interview to dispel any taint if Your Honors would find the first interview as a custodial interrogation. And then back to the waiver, Your Honor, regarding counsel's position that there was no waiver. It is very clear, as counsel said from the video, from the forms, that the juvenile and his mom understood their rights, executed the form. Then, not only was the juvenile and his mother afforded the opportunity to speak alone, not once but twice. The first time, it was quoted, "If you guys need a couple of minutes, you can take as much time if you want to talk amongst yourselves." That was a 12-second pause after that question of that. And then secondarily, do you two need a couple of minutes to talk amongst yourselves, or do you want to have a conversation with Danny and I? Are you okay to do that? You let me know. If at any time you want to take a break or stop the interview, you too have the authority to do so.
And what was the response to that?
They did not have a response to that. At that point, the Detective Callahan starts just discussing about cooperation, as you can see on the video. The juvenile is kind of with his head down, but making eye contact, and then when the...
Did he ever affirmatively say, "I want to talk to you"?
He did not, but he did waive his Miranda when he answered officers' questions, specifically, Your Honor.
So you're saying that's an implicit waiver?
Correct, Your Honor. When at 9:24 in the interview, what is the deal with the firearm? Can we start with there? The juvenile lifts his head up and says, "Yeah." So that was a very clear indication that I want to talk about the firearm, and juvenile lifts his head up, makes eye contact, and says, "Yeah," and then starts talking. So it is clear that was a implied waiver where he is answering questions of the detective.
Was there any conduct in the second interview from the juvenile or the mother that would have led one to believe that they were invoking their right not to answer questions?
No, Your Honor. I didn't, as a review of everything, I did not see any indication that they were invoking any rights. When the mother did want to invoke the right, she was very clear. She interrupted. She said the grandfather is coming and that she wanted to get a lawyer. They stopped the interview. They did not ask any other questions. So the mother did eventually do that when she felt it was necessary. And just in terms of the expert opinions, I know the council did not discuss this, didn't have a chance to, but the judge was well within her discretion by discrediting both of the doctors in this case. Substantial deference is afforded to the motion judge in cases like this, as she had the opportunity to observe the witnesses testify. Both of the experts were discredited based on contradictions in the video themselves. On the cross-examination, it's clear the Dr. Leahy is saying, "Oh, the juvenile wasn't looking at all," but then the video's pause, and, "Well, where is he looking?" "Oh, he's looking up." So, I mean, in terms of the expert opinions, the motion judge was well within her discretion to discredit them, and substantial deference is given to her in that case.
What's your best case about that an hour and 15 minutes is sufficient to attenuate the taint?
The taint, Your Honor, I believe Watkins, it's in my brief, 375 Mass 472, is a good case on point for that. Especially in that case also talks about how the mother was present in the second interview, as in here. That's really the important part, and also that the second interview statements weren't a product of the first interview statements. And
there's more of it. Aren't there cases where the time difference is longer than an hour, and they found that it was still tainted?
Yes, Your Honor, I believe so. I don't know a case on the top of my head right now. I'm happy to submit a letter, but I do believe that there are cases that say that. However, I think what's really important is the substance and the events that occur. And in this case, where they are bringing the juvenile home, then they bring him back. The mother's present. They
He
tell.
never gets home. I mean, you say they're bringing him home. He never gets to the house, so I'm not sure how that plays into it. I mean, they're in the car for like 10 minutes before they turn around and they come back to the station. So what difference does it make where they were going?
Correct, Your Honor. I mean, he didn't ever get home, but I think that's why it is important to look at the totality and what was asked and how the gun was not even referenced in the first interview. And it was clearly a very different interview in the second interview, which is why Detective Callahan was so upfront with both juvenile and his mother by saying, we need to talk about the gun.
Do you know if either Lieutenant Brooks on the street or the detectives in the first interview said anything about how the defendant was going to get home after?
I'm sorry, Your Honor?
In other words, during the interview, the first interview, and the ride partway home after, what would the juvenile have understood about how he was going to get home after? He was waiting at a bus stop before the first, encounter. What would he have understood from what the police said about how he was going to get home?
So correct, Your Honor, that he was at the bus stop. I know this isn't really in the record, so I don't want to, but I would say that they give a courtesy ride there, a courtesy ride back. I know that at the end of the interview, Detective Callahan said, let's get you clean up if you want to make some calls. I don't know if there was any conversation where he asked for a ride home. It's just not in the record, or the detectives offered, but I do know that he was brought via cruiser and that he was being driven home via cruiser.
And no question, he made incriminating statements in the second interview.
I'm sorry, Your Honor?
No question, he made incriminating statements in the second interview.
Correct, Your Honor. But that was post waiver of Miranda. If there are no further questions, I would rest on my brief. Thank you.
Thank you. Very well argued by both sides. Thank you kindly. Our next matter is 23P1417, Commonwealth versus Ahmed SHABAZZ.
Good morning. May it please the court, Jean Liddy on behalf of Ahmed SHABAZZ. This is a case where cumulative errors resulted in prosecutorial misconduct, and advocacy was stretched beyond the bounds of what was appropriate and resulted in numerous errors. In addition, the required finding should have been allowed because the drug certification wasn't admitted.
Did you argue that in your principal brief?
I have it in my reply brief, Your Honor.
So, do you know if we can consider it if it's raised for the first time in a reply brief?
The Commonwealth did raise it in their opposition and spent some time talking about it, and so I responded in my reply brief. But I think the way to approach this case would be to kind of bookend the opening and the closing. And normally the opening, standing alone, even if it is argumentative, may not be enough, which when you take it together with the officer testimony and the closing and the interjection of severed co-defendant Johnson, I think that rises to the level of cumulative effect of the errors. For example,
Do you think that, let's assume for the sake of discussion, all we're looking at is the east bedroom.
Yep.
In the east bedroom, we have, and if we want, we can look outside the bedroom into the kitchen. But in the east bedroom, we have defendant, right? We have the scale, right? We have his personal papers. Right? We have the I don't know what kind of a sheet you want to call it, but it's got the amounts and the figures and the prices, right? And we have, I forget how many grams of cocaine. 8 grams, 14 grams, something like that? 8 grams?
Well, that's a little muddied, Your Honor, and I would counter with that. The drugs are found throughout the house. There's the west
Some
bedroom.
drugs are found throughout the house. In the east bedroom,
Yep.
how many grams?
12.5 in Mr. Hassan's pocket, who was the co-defendant. And that's where it gets a little complicated, and why I would suggest the drug cert and some of the testimony is problematic.
Was
And the
there any
reason I
other,
say
was there any
that,
other cocaine found on the, in the east bedroom?
there was some alleged or purported cocaine that was field tested, found on the scales, and there was some cocaine that was alleged to have been cocaine found in the coffee filter. Now,
Right,
these
the coffee
items,
filter,
right,
the crack, okay.
and these items
So
were,
just that snapshot right there.
right?
Would you say that's enough to hook your guy?
Well, again, we have the issue of the co-defendant, Mr. Hassan, and my defendant, my appellant, Mr. SHABAZZ, who left the bedroom, and there was a break in time, and then they went in the basement. And that was but to your point, the officers took some items, the Pyrex, some money.
I didn't even get into the cutting agents. We're not talking about the stuff in the safe, in the closet. I'm just talking about those things that seem to be in plain view in the east bedroom where he was.
Well,
Is that
the
enough to hook,
safe,
is that enough to hook him on constructive possession with intent?
I would say no. And I would suggest that there's a strong argument for that. And the reason is Mr. Hassan and Mr. SHABAZZ left that bedroom, went down into the basement. The items were removed from that bedroom and from other places and taken into the kitchen. So we're not really sure if the item on the coffee filter was cocaine because it was field tested, and there was no certification admitted into evidence. So that's again kind of...
Let's assume for the sake of discussion that all of those things we just talked about that were located in the east bedroom and the cocaine was in fact cocaine. Is that enough to hook your guy? Notwithstanding that they told them they could leave and they go back and they go down into the basement, all that. In that bedroom alone, at that moment, those things that I've just talked about, his personal papers, the sheet, the scale, the cocaine, him, is that enough for possession with intent?
I would suggest no, because there were other people in the room. It was a common house. There were a lot of people in and out of it. And then I would also...
You don't think a reasonable juror could hook him on possession with intent, either by way of joint venture in that room, with those things that we just talked about?
Is mere presence enough?
Not mere presence.
It's not. And I would suggest that an argument could be made that there was presence, arguably, because you had several people in and out of that room. And we don't know how long he was even in that room, because when the police...
But we know he had his personal papers in there, right? We know he had a
We did have
job
personal
application.
papers. We did. But those apparently were in, if my memory serves me right, now that we're talking about it, I'm kind of remembering that the personal papers were in, I believe, a backpack in there. So it's not as if the personal papers were next to the price sheet or next to the coffee filter or anything like that. And you could make the argument, I suppose, it would be antagonistic, that the cocaine found on Mr. Hassan would indicate more of a possessory tenet, to the cocaine. And the heroin was found in a locked safe in a closet. He was not found guilty on that. He was found guilty on possession with intent to distribute cocaine.
I'll let you pick it up from there.
All right. So, again, we also have the muddying or the cumulative effect, which I would suggest is improper, with Mr. Johnson. And that kind of launches into the opening argument of the prosecutor, who talks a lot about Johnson. And that's
But how was your client prejudiced if the jury found him not guilty of trafficking in heroin?
Yeah, and I know that that's the Commonwealth's argument, but when you have a situation, and I would suggest there's a counter-argument that's stronger than that, and the reason I would suggest that is when you have a situation where, from the outset, from the inception, the prosecutor is talking about, to the jury, arguing in his opening, that the house was a trap house. The driver was drug addicted. Mr. Johnson was a big-time drug dealer. You know, that's what we're talking about here. And the prosecutor knew that Johnson had been severed, not only severed, but that the purpose of even talking about Johnson was because, just to say why the police went into Loftus. And the prosecutor also knew that there was no joint venture with what was in Loftus, because Judge Mason found that Loftus, that Johnson was not in Loftus long enough to be constructively possessing anything found within there. And the conversation...
Is there a difference between joint venture and joint possession? Did the judge give a joint venture instruction?
I don't believe he did, no, but my memory may be failing me on that, Your Honor. I would have to look more closely at that. But I believe that, again, also he didn't find Judge Mason didn't find joint venture because the telephone conversation in booking with the three men, Judge Mason found was too vague to indicate that Johnson had a joint venture with the men in the house, which would be SHABAZZ and Hassan. So again, when the prosecutor is opening...
But there was no objection to these points that you're raising about the opening. There was no objection, right?
Yeah, I understand that, but...
So probably, at least it would appear to have been fair game, that this was the prosecutor's representation to the jury of what he fairly expected the evidence would show.
Well, I guess the question would beg, is it fair game to talk about evidence that isn't going to be able to come in? And we had that happen. We had the prosecutor in opening talk about, the driver of the car was drug addicted and giving a ride to Mr. Johnson because, in exchange for drugs. Or the lessee of 3 Loftus was, a drug addicted person and was renting the house out, to people so they could deal drugs. Or again, the theme of the prosecutor, the trusted friend, to guard the drugs. He's this big-time drug dealer. And so these types of items that he argued were improper and prejudicial.
Why? Are you saying that he knew at the time that he made those opening statements that none of that was coming in?
Well, the only witnesses he called were police witnesses. So it would stand to reason that if he didn't call the driver of the car to say, hey, I was addicted and, I was giving this man a ride, and even if he did do that, which he didn't, even if he did do that, again, you're treading beyond the purpose of the limit of Johnson as to why the police went to Loftus. You're getting into the crimes of Johnson, and that Johnson was this big drug dealer, which is the theme of the prosecutor, improperly, I would suggest. The theme of the prosecutor to argue that in opening and have that be a common thread. And then at the end, talk about...
You're not suggesting that even if he reasonably believed that he was going to elicit this evidence and then doesn't, that somehow makes the opening statement improper?
Mm-hmm.
Mm-hmm, what?
I'm sorry, I'm not understanding your question.
My question is, are you arguing that because he didn't deliver on everything that he said in his opening statement, then there was something improper about the opening statement?
Well, of course it's argument, and of course one cannot open with argument. He could have said the evidence will be...
Doesn't he say that? Doesn't he say, ladies and gentlemen, this is just my opening statement. It's just my way to show you what evidence I expect you're going to see.
He could have said that.
He did say that.
But he didn't say the evidence will be the person that's addicted is renting the house out, or that Johnson is this big-time drug. He could have said that, but he didn't say that with all of those pieces of evidence. He said it with a couple of them because maybe he knew he could do that. But in some of the things, this is a large-scale drug dealer we're dealing with here, folks. Okay, all right. So, at what point is he treading into his own opinion of the defendant's guilt and offering that and making an argument and weaving it in with trusted friends and so forth. And when does it become improper? And that's the rub and the cumulative effect that I suggest happened. In addition, when you look at the closing, you have, again, Johnson was operating out of 3 Loftus. Okay, well, we know that that was improper because Johnson was not in the trial. And Johnson, the case is about, we know Johnson was not operating out of 3 Loftus because Judge Mason said in his finding, which is in my record appendix, he said there was no joint venture. There was 2 infrequent.
Why were they at the house to begin with? Why were the police at the house?
Well, it could have been cured, and to your point, it could have been cured by a brief, Mr. Johnson was stopped, the police got a warrant, the police went in the house.
Why were they at the house?
They were at the house because of what they found in Johnson's backpack.
Did they have an arrest warrant for Johnson?
Yes. Yes, they did.
And did they have a search warrant for the house?
They got one.
Okay.
They got one, yes, they did.
I want to ask you about the jigsaw puzzle argument in closing. Why is that a problem? We're doing this puzzle together, you and I and everyone here in court.
I would suggest that that aligns the prosecutor with the jury. Using the pronoun we. He's incorporating, and again, some of these things taken in isolation, okay, maybe they might be enthusiastic or a little over the top but when you take everything together and you start with the opinion and some of the testimony and you talk about we're doing this puzzle, you and I, it's problematic because it implies to the jury that they're being aligned with the prosecutor and that he might have some information they don't have.
Well, what about, actually, upon further inquiry, we learned that the officers placed these items here. We learned that this cell phone was placed on top of the Domino's pizza box. Is that improper?
Again, yeah, I think I touched on it earlier. You mean in his closing when he said we learned?
Right, so in other words, both lawyers used we.
Yeah, I mean, I think that's fair. We learned. Okay, we learned, something happened in the course of the trial. But putting a puzzle together, you and I, that has a different connotation than we learned what the evidence was during the course of a trial. Okay, so we learned someone was stopped. We learned that you heard from Officer Vivori that he overheard a conversation. Okay, that is fair game. But to say, well, we're doing a puzzle about what Officer Vivori meant about that. And then I think I'm running out of road here. It's just such an interesting case. But I did want to touch upon the certification not being admitted as well, which the prosecution, the Commonwealth raised. And I wanted to throw in that in my reply brief, they argued Dawson. And I don't think they went far enough with Dawson because with Dawson, they say that you can, the government says, with Dawson, you can have circumstantial evidence that a substance might be a contraband or a drug. But I believe that Dawson also says that it's a rare case where just saying something is enough. You have to have more knowledge. And I cited Charles in there for the court's consideration because that would be a judge could make a finding as to how a police officer could opine to what a particular substance was or is. And I believe in this case, the officers that testified, that inquiry was not made, and one of them testified that he believed it was cocaine in the coffee filter because it was on the evidence report. So I touched on that because the Commonwealth did, and I wanted to add that as well for the court.
Attorney Lee, thank you kindly.
Thank you.
We'll now hear from Attorney Swan for the Commonwealth.
Good morning. May it please the court. Sarah Swan for the Commonwealth. Before I start my planned argument, I do want to respond to counsel's raising the issue of the drug certificate. Mass Rule of Appellate Procedure 16C states that no new issues shall be raised in a reply brief. That issue, well, first of all, the reply brief has not been docketed in this case, and secondly, should that issue have been raised, it should not have been and is not properly before the court. Nevertheless, if the court would like me to discuss that briefly, I can. The Commonwealth, the prosecutor opted intentionally to not introduce the drug certificate. There was a substitute chemist who testified. That substitute chemist's testimony was permissible, and she in fact stated that in her opinion the substance was cocaine. There was no cross-examination by defense counsel of the substitute chemist, and in defense counsel's closing, he in fact referenced that finding and used it in his closing to state that that was cocaine. So I'll leave it there at this point.
What do you say about this constant connection with Johnson, who wasn't in the case?
Yes, Your Honor. He was a severed co-defendant. He was severed due to Bruton issues, not anything having to do with joint venture or aiding and abetting. The purpose of that testimony was to provide background and context for how the investigation resulted in a search of 3 Loftus. The judge was very clear that both in discussions with counsel and in his instructions with the jury of that purpose in that context. For example, I'm going to try to say this here. Well, he gave both instructions during trial and in closing that Marcus Johnson was not on trial, that any evidence during the trial, that any evidence that was found on Marcus Johnson was not to be attributed to any of the defendants on trial. It was very clear in their discussions what this limited purpose was, and that is the result. And I think that is shown, evidenced in the jury's verdict. As counsel pointed out, that indeed the jury found the defendant guilty on 1 count of possession with intent to distribute cocaine and found him and acquitted him of the remaining 5 charges. So had there been any import of anything due to do with Marcus Johnson, we would see it in that verdict. And in fact, the jury parsed out and was discerning in its findings, limiting it to just that 1 count. I'll also point out that the 12.5 grams that was found on the co-defendant, the judge was also clear that that amount was to be attributed only to Hassan, not to SHABAZZ. I would also argue in our brief, pretty detailed, that there was constructive possession. But before I do that, I do want to point out, as is stated in the brief, that that argument, the Commonwealth would argue, was not raised sufficiently and is not properly before the court for appellate argument. It's alluded to. There isn't a discussion of the standard, of the Lattimore standard, or how the facts apply under that review. Nevertheless, the constructive possession, as Justice Desmond pointed out, when you're in the east bedroom, there's more than sufficient indicia that the defendant was in that room. He was observed leaving. His paperwork was found there. And then all the items that are there, including the cocaine that's on the coffee filters. I'll point the court's attention to Alcantara, an appeals court case, where the appeals court found that there was constructive possession, where there were documents found in a dresser drawer, and then the drugs were found in underneath a bathroom sink, and the constructive possession was found there. And so the distance between a drawer and a bathroom sink is akin here. In fact, so I don't think that the distance is not as important as it was raised here by counsel.
At trial, did it come in that Mr. Johnson had $30,500 on his person?
It did come in. It did. However, the judge instructed the jury whether monies or evidence found on him was not to be part of their deliberation, their consideration.
And in the east bedroom, we had the scale, the cocaine, the defendant's personal papers, the blowout bag.
Dealer blowouts, baggies, rubber bands, and...
Price sheet.
I'm sorry?
And the price sheet.
And then we have the ledger, yes. That is very detailed, in fact, laying out multiple amounts of cocaine, crack cocaine, and heroin, and the prices that they would be selling that cocaine or those drugs for. So it is the Commonwealth's position here that the trial was properly handled in all aspects by the trial judge, that there was effective, proper lawyering on behalf of both defense counsel and the Commonwealth, and that the trial judge effectively managed this trial of two defendants, again, as evidenced through this discerning finding by the jury of the one guilty finding and the acquittals on the 5 other counts.
Do you agree that there were some things in the opening of the government that were probably better left unsaid?
In the opening, I do not, actually, Your Honor, agree.
Well, is there any evidence that the person in the house, the homeowner, was being given drugs?
Specifically, there wasn't evidence of that. That's correct. I do believe there was.
Where'd that come from?
That I would argue 2 things. One is sort of this hyperbole that is permitted, and that the jury is presumed to understand that that counsel is a strong advocate. So
Do you think that was an appropriate argument?
Appropriate leans toward a decision as to, I would prefer it not be said. Do I think it was an error? Absolutely not. And there was also, for what it's worth, the expert testimony of Investigator Bowler, who did talk about a trap house. And with a trap house, you do, in fact, it is an exchange of likely drugs for the use of the home. So that could be a drawing of an inference there as to the person who got in the vehicle. With respect to the use of "we" in the closing, I'll address that as well. Again, something better left unsaid, most likely. However, it is permissible, and the SJC in Commonwealth v. Jenkins has stated that it is merely a means of involving the jury and suggesting that the prosecutor and the jury review the evidence together when that issue was raised in the Jenkins case. I would argue that that is exactly what happened here and nothing more. If there are specific questions, as you know in the brief that the Commonwealth has submitted, the Commonwealth believes there are 3 areas that sort of govern the variety of claims raised in the defendant's brief. I can address those areas further. We have ineffective assistance of counsel and judicial error, prosecutorial misconduct as well. With respect, we've addressed some of that, but there's also that with respect to the eliciting of improper testimony with witnesses, and then the sufficiency of the evidence, which we've addressed mostly here already. If there are particular questions, I can address those now.
Hearing none? Thank you kindly, Attorney Swan.
And thank you very much, Your Honors.
We're going to take a brief recess.
Court, all rise.
So, resuming.
Good morning, India
Good
Minchoff.
morning. The next matter on our list is 23P1418. Is it MUSTO?
MUSTO.
Guy MUSTO versus CAROLYN MUSTO. And Attorney Minchoff.
Yes, thank you. Sorry I got a little premature there. Good morning once again. My name is India Minchoff, and I'm here on behalf of CAROLYN MUSTO. Judges, I'm sure, as you stated earlier, that you've read all the materials. What I'd like to do is I'd like to focus on the fact that what we have before you is an interpretation of a divorce judgment that was silent with respect to market fluctuations after the valuation date set forth in the agreement. Now, Judge, do you want to ask a question right now? Okay. So what we have is, and if I could just back up, and I think this is a really significant point, when there's a valuation date established when it comes to divorce purposes, that's because this is the date upon which the marital enterprise, the partnership, has ended.
I'm going to interrupt you for a second. I'm sorry. Let's talk about what the order says. Specifically, what's the language in the order?
The language of the judgment is that 50% of the value of the retirement accounts to husband and 50% to wife as of November 25th, 2020.
No. Let's be more specific. Let's look at exactly what it says.
That's fine, Judge. It says precisely, husband's retirement assets shall be divided between the parties so that husband receives 50% and wife receives 50% of the total value in the accounts as of November 25, 2020.
Okay. So 50% of the total value of the accounts as of a date certain.
Which is a date already established that pre-exists the date of the order. So that's the date of the divorce trial, which is the end of the marital partnership. And as of that date, wife isn't contributing any longer to this marital partnership, but this is now wife's separate property set forth in terms of a percentage, not a stated sum.
Whatever the figure would have been as of that date. 50% of the total assets as of that date. So we can calculate what that fixed number is, right?
But he didn't calculate.
He didn't.
And that's
He didn't, but
significant that
makes
it's
it no
not
less a fixed
calculated.
number.
It would have been very easy to have done so, and if that had been done, I think case law, there's not a lot of case law in this jurisdiction, but case law from other jurisdictions are very instructive because they deal repeatedly with this same issue. And if we have words and say wife or husband is going to get $5, $500,000, that's the amount. Stop, no further. But when you present it in terms of a percentage, and it's not to be confused with saying of the value of that time, because you have to establish a date where that percentage, because after that date, husband is still contributing. He's contributing to it on his own accord through his employer, and so we're not going to use a date to establish the value other than the date where the marital partnership technically ends.
That's not what the judge did. The judge used a date to establish the value.
Correct, to establish the value, but then he's silent as to what happens to wife's separate property. And it's her separate property at that point, where there's issues with respect to fluctuations, gains or losses until the time of segregation. And if you think about it, so now wife is essentially being asked to make a gift of any appreciation on her separate property to husband. At that point in time, it's no longer husband's property. This is wife's property established as a date of November 25th, 2020 with the value, but then there's increases and decreases.
What do we do
subject
with
to
the
that
fact
time.
that it was Judge Boyle who presided on the judgment and also ruled on the motion for clarification and the 60B motion and the motion to compel, and basically said it's not ambiguous, it doesn't include depreciation, it's as of November 25th.
November 25th, 2020. So I would say that Judge Boyle actually vacillated, because when he was asked at oral argument if this was the intent, he actually stated repeatedly 3 times to questioning from my predecessor counsel, Essentially, of course, otherwise people would delay in executing the quadro.
He did, but he fixed that. He said, notwithstanding whatever I said in oral argument, this is,
And so if we get to that point where it's notwithstanding what he said in oral argument, and we finally get to the point where he issues an order on clarification, because I don't think there can be any doubt that at a minimum, it is ambiguity to have silence. There's not a dispute about that.
I think reasonable minds may differ there.
And so that creates an ambiguity. So
I'm not sure.
Where is
There
it?
can be any doubt.
I'm sorry. Where is the silence? I'm not understanding. You keep
So-
saying silence. It seemed that the judge was very explicit in how he was dividing up this property, the value of this property.
the silence was he didn't address, period, what would happen with wife's share after that date of value. So wife's share.
To address that.
Well, respectfully, I think you do have to address it because it's not being done on segregation that very day. So there's a time period between the date of valuation, percentage stated, not a dollar value. There's a time period between that date and the date where we actually have the quadro being effectuated. And there are differences. In this case, we're looking at $1 million of a difference on wife's 50%. And this is not on the contributions from husband or from husband's employer. This is all on the rising of wife's 50% of her separate property at that point.
If I have $100 in my pocket and I tell you I'm going to give you 50% of the $100 that I have in my pocket today, and tomorrow, does that number change? What's 50% of $100? Does that number change tomorrow?
That's not
I'm asking, does that number change tomorrow?
If that's $100, it's being invested somewhere and it's my
That's not the
$100,
question.
it does
That's assuming
change.
facts that are not in the question. I'm saying I have $100 in my pocket, and I'm telling you I'm going to give you 50% of the $100 that I have in my pocket. Does that number change tomorrow or the day after or the day after?
If you give the $100, but what achieve if it's still in your pocket? Because that at that point, you're not saying that at that point is my separate money. It is no longer your $100. I have $50 and you're receiving the growth on my $50.
So the judge said, to the extent it needs clarification, no, that's not what I meant.
And so he did say that, and that's why we're here, because we're finally to the point where there was clarification, and then that takes this court to the next view of how to treat the interpretation that was given. And that is looking at the judgment as a whole, looking at the key phrases within the judgment, and also at this point, looking at the fairness and equity of the judgment.
Why can't we just look at the plain meaning of the words?
The words aren't there to look at plain meaning. If you're going to look at plain meaning, we're looking at the meaning of equalization. We're looking at wife being an equal partner, and we're looking at conclusions of law that essentially say I have to establish a date upon which this economic partnership has ended. That is the date, and this is what all judgments say. It's just a silence on the next sentence. All of these divorce judgments and quadros establish either a fixed sum, $50, or they say 50% as of a date, and then the next sentence is with fluctuations in the market, gains or losses being attributable to each party's share, their percentage, until the date of segregation. And so your question is, okay, well, he finally gave me clarification, Judge Boyle did. Now, you have your clarification. The question for this court is, in its standard of review, now that that clarification has been given, you look at the divorce judgment and you see throughout that he's saying there's an equalization with respect to the 50-50 minus inheritance and some payment that my client owed to Mr. Musto.
Did she ever make that payment, by the way?
I believe she did, Judge. I haven't represented in the probate and family court, but I don't think there was any issue with respect to that. In fact, I know she did. But back to the point, which is Now you look at this and you say, okay, the intent of the agreement, the interpretation, the intent, the words that are used, and you're saying, let's look at words. So these are the words with respect to an equalization with respect to these parties. And if you look at fairness, and now I know my brother counsel says, oh, well, if it had been the other way around, we'd be arguing differently. Well, I'd suggest that they'd probably be arguing differently. But when you look at fairness, this is her separate property. So whether it's 1 month, 5 months, or however long of a period, whatever happens to her separate property, fluctuation, decreases, whatever the market is, that belongs to her. That should be assigned to her, not to him, because if you want to talk about a windfall, having it sit there for any period of time is a windfall in this particular case to him. But if you flip it on its other side and say, okay, he's supposed to give a dollar value, as the court would suggest. $50 in my pocket today is $50 in my pocket tomorrow. Well, if there's a decrease in that market, there might not be $50 to give to Ms. Musto as far as a quadro in these retirement accounts. So it's the valuation date, and then whatever happens to that percentage, because we don't have a sum certain. We don't have $50.
The judge had no obligation to divide these retirement accounts, and I say accounts. He had no obligation to divide the accounts 50-50, right?
He had an obligation to address the accounts. He had no obligation to do the division of 50-50. He could have done some other percentage.
Right. So if he had, if you lay out the options he had, he could say she gets 50% of the account, or he could say she gets 50% of the value as of a certain date. He had the discretion to do that, didn't he?
I think there's somewhat confusion when we talk about value as to a certain date. The date that is used for the valuation is not to turn it into a sum certain as of that date. What it's to do is to put an end to the fact that wife at this point is no longer a contributor to this marital partnership. So let's just say the date had been used as of the date, 50% of the value as of the date that the quadro would have been implemented and the amount segregated. Let's just say that by way of example. If that had been done, what that would have done is rewarded wife not just on 50% of growth or decreasing in value, but on husband's continued contributions to the retirement account following the date of the end of the marital partnership and technically the end of her contributions to this economic partnership that they had through the marriage. So that could never be stated. The date of November 25th, 2020 shouldn't be confused as somehow it's the value as of that date percentage-wise, or I mean in terms of the sum. It's a percentage as of the value as of that date to which she's no longer going to be receiving his contributions, husband's contributions.
Well, what if he didn't mention the date at all?
We have to mention a date because
what if he didn't mention the date at all?
we would have been on for clarification for a different reason.
Well, how would the property be divided then?
You wouldn't have been able, I would have been seeking if no date had been mentioned, period, we would have been in court saying, Judge, we're seeking clarification, maybe even at that point to amend his findings under Rule 59, because you have to have a date. There is not a single case where you're not going to have a date in which to measure this is now wife's separate property, her additions, her decreases in the fluctuation of the market. You have to have a date.
Let me ask you this. Should we be unpacking any of this? Because there was a prior motion that was filed, a motion for relief from judgment. That was denied. And then the appeal was dismissed back in 2022. So wasn't that the end of the matter right there?
I do not believe so, Judge. So first of all, let me say two things, and I'm noticing my time ticking, so I'm going to talk just a little bit faster. One, res judicata, the elements of res judicata, whether it's claim preclusion or issue preclusion.
Not much faster, please.
Sorry. The elements of claim preclusion or issue preclusion haven't been satisfied in the context of a singular case. Beyond that, the Rule 60B, not 60A, and I point that out because a case cited by my brother counsel really focused on 60A potentially being an avenue to seek a clarification. And there was some difference in whether it was or it wasn't, whether it was substantive in that particular case cited by my brother counsel, but it's of no consequence. We have a judge here that didn't have hearing, didn't adjudicate the merits of the Rule 60B with a stated reason, such as, I'm not buying your argument here, I'm not going to give you the relief you're seeking. And frankly, it wasn't the proper procedure in which to move for clarification, which to move for. Can you tell me what the interpretation is supposed to be? The only proper procedure for that is, in fact, a motion for clarification. And I just want to point out very quickly, if I may, that there was another case that was repeatedly cited by me as well as my brother counsel, and that was the Connor versus Bennett case. And the SJC in that case essentially said, go back to the lower court, seek clarification. And frankly, we have the same language that we have here. In the appendix that I filed is the probate court after the clarification, given the same arguments that are here.
What's the site for Connor v. Bennett?
The SJC Bennett case is, oh, here we go. 481 Mass 567, and in my appendix to the brief was the lower court decision when it went back on remand. I'm not sure it was remand, but back to the lower court on the motion for clarification. Same exact issue. The judge in that case said, of course, the silence means, and it should mean, otherwise it's unfair to one party, that the gains and losses are going to be attributable to each party's share. It was a percentage of the value.
I think we got it.
Thank you. Hope I didn't talk too fast.
Attorney DeMello, please.
Good afternoon, Your Honors. Scott DeMello on behalf of Guy Musto. May it please the Court. I think, Justice Hodgens, that you hit the nail on the head. The problem with the appeal as it's before this Court, the only thing before this Court, is the trial court's denial of the motion for clarification and the denial of the motion for compelling husband to execute a quadro, including gains and losses. However, that followed the denial of the Rule 60B motion that wife had filed. And what's very important about that is the 60B motion asked for the identical relief. The motions were almost word for word identical. A couple little stylistic changes here or there, but they effectively argued that the judgment didn't include gains and losses, that the judge had in fact intended to include gains and losses, and however, it didn't. So therefore, the judgment needs to be clarified. Wife filed that motion. We filed a detailed opposition to that motion, all on substantive grounds. We never once argued a procedural ground. We didn't argue that a Rule 60B motion was not the appropriate vehicle. Judge Boyle reviewed the papers and denied the motion. What I think is most important is the wife filed a notice of appeal on that. She appealed because she realized that it was a final order on a 60B motion and that she had to appeal the decision. She did. However, she failed to prosecute the appeal. While the appeal was still pending, she then filed her motion for clarification. And at that point in time, shortly thereafter, the appeal was dismissed. And it may not be res judicata. I fully recognize that. I had argued down below, and my sister makes a big deal of the fact that I use the words res judicata. However, I think that this court's decision in Catalano and the Supreme Judicial Court's decision in Littles make it abundantly clear that a lack of an appeal of a final order means that the order is final, and that you cannot resurrect appellate rights by then filing a second motion asking for the exact same relief and then appealing from the denial of that motion, which is exactly what the wife has done here. And I think the facts of Catalano are almost identical to the facts here. In Catalano, the plaintiff filed a complaint. The defendant moved to dismiss that complaint, which the court granted. The plaintiff then took a single justice appeal of the denial, of the granting of the motion to dismiss. And the single justice said, no, you're not supposed to be before me on a single justice, I'm denying the appeal. They never appealed at that point. They never took a further appeal to the full bench. They then filed a motion to enter a final judgment because procedurally it was kind of a little wonky. They never entered a final judgment. They filed a motion to enter final judgment of dismissal. A second judge granted that motion. They appealed from that. And what this court said in Catalano is, the appeal is not properly before us. You waived your rights by not appealing the first dismissal of your appeal. You should have gotten that, and you should have appealed the first final order granting the motion to dismiss. And because you failed to do that, you can't now come back and just file a second motion. Little's is very similar. Little's dealt with an interlocutory appeal on qualified immunity. The defendants in Little's raised a motion and filed a motion for summary judgment on qualified immunity. The motion was denied. They didn't appeal that motion at that point. They then waited 2 years, let discovery take place, and they filed a renewed motion for summary judgment. And at that point, the Supreme Judicial Court again said, you can't revive your appellate rights. Your appellate rights were when the original motion was denied, and because it's qualified immunity, they allow immediate appeal. Because you didn't appeal that decision at that point in time, you can't appeal it now by just filing a renewed motion without any change in circumstances. And I would submit to you that's exactly what we have here. Wife asked in her 60B motion, please grant me gains and losses. The judgment didn't grant it to me, but I believe you intended to do that. Denied. She then files a motion for clarification. Denied. That motion for clarification doesn't resurrect her appellate rights of the failure to do the 60B motion. And as we argue in our brief and we provide you with the cites, Rule 60 is the appropriate vehicle for filing a motion for clarification. And I would submit that Rule 60A and Rule 60B overlap, particularly in the 1 year period after the judgment is entered, which is the period that we're talking about here. The court's DeLuca, I believe it was DeLuca v. DeLuca, clearly said that 60A is the appropriate vehicle. But what I think is important is that DeLuca also provides you with the reason why what the wife called the motion isn't really relevant. In DeLuca, the wife filed a motion for relief, didn't designate what rule she was filing it under. The trial court granted the motion under 60B-4. This court affirmed the decision, but under Rule 60A. And what they all say is you look to the substance of the motion, not what somebody calls it. The wife may have called it a 60B motion, but it was a motion for clarification, which is appropriate under Rule 60. The motion was appropriate, it was appropriately addressed by the husband, and it was appropriately denied by the trial judge, because it was him that decided, as Justice Desmond has pointed out, the judgment says what the judgment says. Silence does not create an ambiguity. The judgment gives a formula for determining the sum certain that was to be provided to the wife on the division of the 401k. And the only reason that the wife hasn't gotten that money is because she's been fighting for 3 years now over what the meaning of that phrase is. This is not a case where you actually look to the intent. What did Judge Boyle intend? We know exactly what Judge Boyle intended. He intended not to include gains and losses. And what I think is most important, aside from which motion is before this court, what I can tell you is not before the court is the judgment of divorce. The wife didn't appeal the judgment of divorce. She also didn't appeal the 60B motion. And I would submit that even under 60B, if she had prosecuted that appeal, the underlying judgment isn't subject to review. It's whether or not the judge abused his or her discretion in denying the 60B motion. Wife argues this case like we're here on the judgment of divorce. We are not. We are motions 2 and 3 after the judgment of divorce. We've got the judgment of divorce not appealed, the 60B motion appealed but then dismissed, and then we have motions for clarification and motions to compel. And I would submit to this court that the motions for clarification and the motions to compel are nothing more than motions for reconsideration of the denial of the 60B motion. And I have not found one case that either this court has decided or the Supreme Judicial Court has decided that says that a judge abuses his discretion when he denies a motion for reconsideration in the absence of a change in circumstances. Here, there are no change in circumstances. It's been the exact same circumstances. The judgment gave us some certain, wife knew it gave us some certain, she asked the judge to clarify it, he denied it, and she just keeps repeatedly filing the same motions over and over and over again. And I would submit that Littles and Catalano say that that's not appropriate. I would just address briefly I don't believe it's appropriately before the court, but substantively, whether or not it's fair or not, even if the judgment of divorce was before the court, the wife would have to show that the judge was plainly wrong, and that the judgment was plainly wrong and excessive. And she doesn't meet that burden here. You have to look at the judgment as a whole in its totality. It awarded her a sum certain from the retirement account. That in and of itself is not appropriate. There is not one case that my sister cites to in the Commonwealth that says that an award from a retirement account must include gains and losses. And I think that that's what the key of the Connor v. Benedict case is. It's not that the SJC passed on it, it's the fact that they passed on it, meaning they didn't even say that you had to include gains and losses, because that would have been the perfect vehicle. It was before the court on whether or not gains and losses were included, and they didn't say you have to include gains and losses. They said go to the court and ask what the court intended. And we know exactly what the court intended here. And if you look at the judgment as a whole, it is perfectly logical the way the judge did it, because there was the $113,000 equalization payment that was awarded to the husband, no gains and losses on that payment. The wife gets a fixed sum, about $400 and some thousand from the 401k, no gains and losses. The fact that they're not equal doesn't mean anything. If you look at the cases all say mathematical precision isn't required. You have to look at the judgment as a whole. And they do not attack the judgment as being plainly wrong or excessive. And unless the court has anything further to ask, I would rest on our brief.
Hearing none, the matter stands submitted. Thank you both very much.
Thank you.
And our final matter for the morning, afternoon, is 24P0682. I'm going to apologize if I butcher these names. LOAYZA versus BABIO.
LOAYZA versus BABIO.
Attorney Chin.
May I begin?
You may.
Good afternoon, Your Honors. My name is Alan LOAYZA, and I'm self-represented. In my appeal, I make two requests. First, I ask this court to find that the trial court incorrectly calculated my child support obligation using old attributed income.
So that's conceded, right?
Yes, Your Honors.
Okay.
My second issue is I ask the court to find that the trial court's award of attorney's fees was unreasonable and to vacate the award. And here's why you should. As you stated, opposing counsel has conceded the first issue that they agree that.
For those 4 months, correct?
Yes, for those 4 months, December.
I want to make sure I understand. I read the wife's brief as saying that the judge made a mistake, and I think, is it paragraph 73 of her findings, where she used the number 1341 per week instead of 560 per week?
Yes, she
For
used
adjusted gross income?
1341 is the attributed income. That's the error.
And that's the error?
Yes,
But
because
then, as a result, the judge, how do we know that the judge used the 1341 number and not the 560 number in the judgment? Because in the judge's rationale, she says that she imputed weekly income to the husband as reported on his financial statement filed on March 6, 2017, which was the 560. So she made a typo in that paragraph 73, but how do we know that that infected her arithmetic in the judgment?
there were different time periods that the court calculated the child support obligation. For the specific time period at issue here, look to appendix page 83, paragraph 73, and that's where the court used the 1341 figure that they used to calculate my child support obligation for the relevant time period, December 2016 to April 2017. And
So are you asking us to recalculate the child support obligation and come up with a number?
I am asking you to find that using that old attributed income amount was incorrect because the court made a separate finding that contradicted that finding. The court said that I was working full-time during the relevant time period on page 73, paragraph 11 of the judgment. And in that same paragraph, the court found that I was working full-time, making $14 an hour. $14 an hour times 40 hours is 560 weekly.
Where were you working at the time? Was that patios? Where were you
I was working for the Summers Pubs Corporation, which owns a pub called Patios.
But then, in the judgment, we can't see the judge's math. Why didn't you just file a motion, a Rule 60 motion, to correct the judgment?
I submit that Rule 60 didn't apply, Your Honor, because the mistake at issue here was not a clerical or a ministerial
How do we
error.
know it wasn't, though? If what's in Rule 73 is a typo, and in a bunch of other places the judge used the number 560, how do we know she didn't use the number 560 in doing the math for her judgment, in the judgment?
Well, the court can review the calculations that were made by the trial court using...
How can we review that? Do we have the worksheets?
No, but in the appendix is the child support guidelines, which give the form, and in my primary brief, I also lay out the specific formula that the court used to calculate the child support obligation.
So why wouldn't we just remand it to the judge for her to recalculate and to determine whether or not she used the correct number?
My understanding is that the trial court judge has retired, so she's unavailable to have it remanded to her. And if we were to remand it to a different trial court judge, I submit that that would be a waste of time because any other trial court judge would have no special knowledge or...
Well, they're used to, they have more special knowledge than we do about applying the child support guidelines.
Correct, Your Honor. But I submit that there's enough for you in the record to...
Even without the worksheets?
Yes, Your Honors, because I lay out the formula that the court used to calculate the child support obligation in my primary brief. Opposing counsel conceded to my statement of facts and procedural history, and opposing counsel has conceded that my argument is correct. So there's no...
What should the figure be?
The figure should be, the court should have awarded $26 weekly rather than the $184 weekly that it did.
And that's a difference of about $4,500?
That's a difference. Over that particular time period, it's a difference of approximately $2,500.
Okay, see, that's where I think there's a little confusion here. So when we say that the appellee has made a concession, it's really not a concession to your argument. The appellee is conceding that there was an error, but it was a clerical error that resulted in a difference of $800. But that's different than your claim, because your claim has nothing to do with the clerical error. You're challenging the judge's determination that you underreported your income, and as a result of that, there's an error of $2,500. Have I summarized that correctly?
No, respectfully, no, Your Honor,
Okay.
That's not correct. The error that the court made was the starting point of the calculation. What was my income at the time, during that time, the relevant time period? That was the court's error, and the court, for the relevant time period, the court found that I was working full-time, and it found that I earned $560 weekly. Yet, it didn't use that amount as its starting point for calculations.
How do we know that?
Because we have we know from from page 83, paragraph 73, that the court attributed income to me in the amount of $1,341. That was the court going back over a year in time to the divorce judgment. That's where the figure came from. That amount of income was attributed to me during the divorce judgment. And the court went back in time and used that figure without any analysis as to why that figure was more appropriate. And by using that figure, the court contradicted its own finding that I was working full-time, making $560 weekly. And that $560 weekly amount is the amount that the court used in all its other calculations of my child support obligation for all the other time periods. It's only this particular time period. So this isn't a mistake of math. This isn't someone getting multiplication wrong, which would be a clerical error. This is a substantive error. The court decided, and we don't know why, because the court didn't support that decision with any findings, but the court decided to go back in time and take attributed income that was attributed to me from the divorce judgment. That's the error, and that's a substantive error. That's not a clerical error. And that's why Rule 60 doesn't apply.
So you're saying it had nothing to do with underreporting your income?
The findings that the court made regarding underreporting of income occurred after this time period. So that particular finding by the court had nothing to do with its calculations of my child support obligation for this time period. For this time period, the court found no fault with my financial statements. As to the second issue, the award of attorney's fees, the court's error was twofold. First, we had a gatekeeping order in place during the pendency of the modification. That order required the parties to get the express permission of the court before filing any pleading or motion. And the court enforced that order sua sponte against me. There were several times during the pendency of the modification where I did not seek permission of the court, and sua sponte, the court rejected my filings. But yet, for this particular motion, the court did not do that. And that's unfair, that the court didn't fairly enforce its gatekeeping order. It accepted the order. And as you'll see on page 66 of the record, the court granted the motion in the margins, ordering me to pay $6,000 in attorney's fees, an amount that was 10 times more than my weekly pay.
And less than $7,200, whatever was the request, right?
Yes, it was less. It was approximately 80% of the request.
What's the standard under 20838 for a probate judge to order attorney's fees?
Discretion is broad, Your Honor, but it's not unlimited. And it's broad, but it's not unlimited. But unfortunately, the court didn't issue any findings to support its award. So we're left to speculate as to the reasons why the award was issued. The court should have issued findings, but it didn't.
Can we review the transcript and decide for ourselves if we think that your conduct was litigious for the sake of being litigious?
Yes, that's actually what I'm asking the court to do, is to review the transcript and determine whether obstructive conduct occurred. I submit that there was no obstructive conduct.
So let me ask you this. Why, if the court didn't issue any findings saying that they're granting $6,000 because of your obstructive conduct, then why are we looking at that?
I'm sorry, I didn't hear the end.
Could you repeat that also?
You seem to be arguing that the court found your conduct was obstructionist, and that's why she ordered $6,000 in attorney fees. Do I hear you correctly?
No, Your Honor. My argument is that we don't know why the court awarded the attorney fees.
Why are you talking about obstructionist?
Because I submit that of all there's an 8-factor test for determining whether an award of attorney's fees is appropriate. And the analysis is a bit more nuanced in this particular, needs to be a bit more nuanced in a case where you have on one side a trial attorney with decades.
Why are you talking about obstructionists?
I'm talking about obstructionist conduct because there was no obstructionist conduct.
Who said there was?
Attorney, opposing counsel.
But the judge didn't say that, right?
No, she didn't.
Okay.
But the reason that's important is because this court and the SJC has repeatedly upheld awards of attorney's fees in domestic relations cases when the court found there was obstructive conduct.
But is
That
that,
may be true. I'm sorry.
And in
so
my
does it
principle,
have to be obstructionist conduct? What about litigious for the sake of being litigious? Would that be a reason to impose attorney's fees?
that could be a potential reason, Your Honor. But that circumstance doesn't exist in this case, and the court could review the record to see. I think the starting point of the court's analysis should be opposing counsel's motion for attorney's fees. What arguments did she make in her motion? What she calls obstructive conduct, justifying an award of attorney's fees, is nothing more than both parties engaging in the adversarial process. For example,
What about the fact that the trial took 4 days and it had to be continued from April to October as a result, when it was estimated to only take 2?
pro se litigants aren't aware of the legal rules. At the time, I was
Even law school graduates?
At the time, I was not a law school graduate, Your Honor. This case took 4 days. 2 of those days occurred during my first year of law school, and 2 of those days occurred at the start of my second year of law school. So I had little legal training. I was not a licensed attorney, and frankly, I bumbled.
So why should that be visited on her? The fact that, according to you, it took longer because, I presume, why didn't you retain an attorney?
I couldn't afford one.
Okay, exactly. So why should your inability to afford an attorney cost her more money because it took longer, because you didn't know, according to you, exactly what you were doing, which made it go 2 days longer than it should have? Why should she have to pay her attorney those extra 2 days? Because you're trying to save money by not getting a lawyer.
Because if the court were to apply that rule in cases like mine where there's a pro se...
It's not a rule, it's a consideration, but go ahead.
If the court were to use that consideration when it's dealing with cases like mine where one side is represented by counsel and one side is self-represented, nearly all pro se litigants would fall under that consideration. It would be unfair, and they would have no way to overcome that. And that's why it's important for the court to take a more nuanced look at the factors, and may I conclude my sentence, Your Honor? The court should take a more nuanced look at the factors, and that's why it's important in the context of a pro se litigant on one side and opposing counsel on the other. The court needs to look at obstructive conduct and make a determination: is particular conduct during the trial merely bumbling and honest mistakes, or does it rise to the level of obstructive conduct and willful, which would go to the point of litigious for the sake of being litigious?
So rather than file a motion to reconsider or to correct a clerical error, you took this appeal for $2,500. Why shouldn't we allow attorney's fees on appeal to the wife, who I'm sure has spent more than $2,500 to defend this appeal?
You should not award attorney's fees because the arguments that I've submitted in my principal and reply briefs have merit. They weren't frivolous. They weren't in bad faith. And to allow attorney's fees in a case where a litigant has meritorious issues would merely punish someone for pursuing their appellate rights. Thank you.
Thank you. Attorney Chin.
May it please the court. My name is Meryl Chin, and I have my associate Ariel Gray here with me today, who was instrumental in writing the briefs.
So you can see that there was error in the figure that was used over that 4-month period of time, right?
Yes, I do.
So how did that error What was the impact of the error? You tell me.
If Mr. Loyoza's calculations are correct, which I don't know if they are, his number would be correct. It's approximately $2,400 that he would be due as a credit. And I do know that in the...
Have you done the math?
I have not done this. I do note that in paragraph 9 of the judgment itself, it says from December 28, 2016 to April 20th, 2017, father shall pay mother child support of $184 per week for 16 weeks. His obligation was $2,944. So that apparently is the judge's calculations, and Mr. Loyoza says that it's $26. I have not reviewed those, but I think that that is the job of the trial court, and that's why I had argued in my brief that this should have been a 60B motion, as Justice Grant brought up. Respectfully, I don't think that the argument he made that Justice Armstrong has retired is persuasive, because I believe it's Judge Texera who's taken over her list, and she's perfectly capable of correcting a clerical error, which I suggest is what it is. In paragraph 73, she says that she attributes $1,341 instead of the $560 that she had attributed to.
So can you tell if that paragraph 9 of the judgment is using the 1341 or the 560?
Well, if his math is correct and he says it's $26, then yes, that would be the math based on the higher number. Possibly I should have done that math. I didn't. I apologize. I just, as I said, I really think it's a issue for remand.
Notwithstanding, you're conceding the point.
Pardon me?
Notwithstanding, you're conceding the point.
Yes, I'm conceding that there was a clerical error. Yes, I'm not going to make an argument when I don't think there is one.
The attorney fees.
Yes, on the attorney's fees. I'm requesting that the court affirm the award. Mr. Loyoza stated in his pretrial memo that it would take, the case would take 1 day to try. The judge...
He wouldn't have been the first litigant.
I do, yes.
Anticipated a trial was going to be shorter than it turned out to be.
I don't disagree.
Don't issue attorney fees because of that.
Right. I don't disagree. But I think that it's relevant to consider, and also why the court gave 2 days, and then it took 4 days. His case took up 3.5 days of the 4 days. My case was 3 hours and 45 minutes. I called 3 witnesses, and on every issue, the judge found in my client's favor. She did not find in Mr. Loyoza's favor on any of the issues. She found that he had not sustained his burden of a substantial and material change in circumstances, and she restored the original award of joint physical and legal custody.
So he lost.
He did.
Okay.
Right? But also, when he lost, he also used 2 days of additional time, forcing my client to incur attorney's fees. And not only was it because of his conduct at the trial, but the judge found that he had submitted, I don't know if she actually called them fraudulent, but she said that his financial statements were inaccurate, his testimony was not credible, his testimony lacked candor. All of those things caused the trial to extend longer than it should have, because I had to question him about those inaccurate financial statements. I had to bring that information to light. I had to challenge his uncredible answers. Judge Armstrong called us to sidebar after approximately 46 pages of the testimony. I don't know exactly how many minutes that was. It seemed like it was close to an hour. And it was on his direct, and she said, "This is a custody case. I haven't heard anything about this child. I don't even know what her name is. I don't know how old she is." So I think it goes beyond bumbling, Your Honor.
That designed to move him along?
Pardon me?
Was that designed to move him along?
I do believe so, yes. And I think that she could have moved him along more if she chose to. I'm not criticizing that, but I've been before judges that they literally have a timer, and we are held to specific timeframes.
Speaking of judges moving people along, I don't really understand why we're here when there's this dispute about $2,500 and some amount that the parties don't seem to really disagree about, and the appellant is pursuing his appellate rights as is his right to do, but it's raising the possibility that there may be a case that results that's going to refer to him in an unflattering light on some of these issues that you've just said about his not being credible and whether or not he underreported his income. I can't really understand why we're here.
I guess you'd have to ask Mr. LOAYZA that. I mean, it's not my appeal. I do agree, and my client, has spent probably more money than the $6,000 is worth. But the parties were just before the trial court last week on a modification that Attorney Gray handled, and we are waiting for a decision now.
Let me just ask you this along those lines. So was there any point when, during this, that you reached out to the appellant and said, exactly that, hey, listen, my client doesn't disagree with you here, let's resolve this and end this litigation?
I did. And in fact, I offered to compromise the award of attorney's fees so as not to have to be here. And I was not successful in that. I guess the only thing I was successful in was giving my young associate a little bit of experience writing a brief and my first time in the appellate court. But, if the court ends up reading the entire transcript, I think you'll see the judge's level of frustration with Mr. LOAYZA. And I've had many pro se litigants on the other side. I do know that hiring counsel is expensive, and there are a lot of people in the probate and family court that do choose to represent themselves, but they don't choose to conduct themselves the way Mr. LOAYZA did. Mr. LOAYZA would not agree to one uncontested fact for a trial. I have been practicing for 31 years, and I've probably done 40 probate and family court trials, and I have never had a case without basic uncontested facts, names, ages, right, things like that. We didn't have any uncontested exhibits. The judge told us we didn't start the trial until noon because the judge said, this is ridiculous. These documents, medical records that I had properly subpoenaed with the appropriate certificate under 79G, he wouldn't agree to allow in, and that would have prolonged the trial even more. So she instructed us to go into a conference room, and she told him that the large majority of these exhibits were admissible and that he needed to cut down the time of this trial and he needed to discuss these with me. And then we had uncontested exhibits after that, but it took 3 hours. 3 hours in court that we should have been using for trial time that I reached out to him to try to do beforehand. I mean, his objections and his arguments were unwieldy, and I think the judge gave him a lot of deference. She let him continue and continue and continue. Most lawyers make their objections fairly concise. They sit down, the judge rules. That was not the case with Mr. LOAYZA. He called 2 witnesses that said the exact same thing, and the judge cautioned him. I don't need to hear, she said, from 2 witnesses that are going to say the exact same thing. So I suggest the
point, it seems to me, is through Mr. LOAYZA's lens, is that many lawyers, if not all lawyers, are inexperienced at some point. And the way a lawyer tries a case on their first trial might look very, very different than the way a lawyer tries a case on their 21st trial. And that's because they've had the experience of calling witnesses and entering exhibits and these types of things. And where he didn't have that training at that time, in this case took a little bit longer than perhaps it should have, he doesn't feel that it's appropriate to penalize or sanction him because he was representing himself. And wouldn't that befall all self-represented litigants?
I do understand that that is his argument, but as I said before, this was more than just how he presented his case. He filed inaccurate financial statements. He refused to agree to the uncontested exhibits. He evaded questions regarding his income and employment, and that is all in the trial record. And Mr. LOAYZA, I understand that he hadn't done a trial before, but we had been litigating this matter, and he had been pro se for several years. He was in court on many occasions, and his pleadings, they weren't half bad. He was in law school at the time. I suggest he had many more resources than other people would have. And, you know, as I said, I have done other trials with pro se litigants, and never has it risen to this level. You know, if he had taken a couple of extra hours, or if he hadn't agreed to some exhibits but agreed to others, but it was just a constant stream of no, 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 and then arguments that just went on forever. And the judge would rule, and he would argue again, and she would rule, and he would argue again. And the case law is clear that an award of counsel fees is presumed to be right and ought not be disturbed, and that a judge has considerable discretion in issuing that award. And I suggest that Judge Armstrong was in the best position to decide whether it was fair and reasonable and appropriate to issue that award, because she sat through the 4 days of trial. And after sitting through the 4 days of trial, she decided that not only had he lost, and not only had he brought unmeritorious claims before the court, but he was obstructionist. She didn't say that specifically, but I believe that if you read between the lines of her judgment, that's really what she was saying.
Well, Mr. LOAYZA might respond that it's an adversarial process. Isn't he supposed to be adversarial?
It is an adversarial process, but I also think in family court that we do things differently. Lawyers are much more inclined to agree to exhibits that they know are admissible and are going to come in anyways, because they understand that they're dealing with human beings, not large corporations that have deep pockets. So we try to take a little bit more of a reasonable approach, and I think that his approach went beyond adversarial. I think it was, the judge even said that he was uncredible, he filed false financial statements. Respectfully, I suggest that that's not advocacy or being adversarial. I suggest that that's inappropriate and grounds for the attorney's fees that the judge awarded. So I'd ask that you affirm her order and remand the issue of the miscalculation or the clerical error in the child support. Thank you.
Thank you very much. The matter stands submitted. That concludes our business for the day. Thank you all. Thank you to our court officers and timekeepers. Court's in recess.
Court, all rise.